Good morning, friends. Important instruction number 2, dated 17th August 2022, pertaining to a guidelines which is being issued by GST-Investigation wing. What are the guidelines to be followed by the field officer for arrest and bail for specified offences under GST law? This guidelines is very important. The complete guidelines is being given in the description box, but the summary of this guidelines is: when arrest can be made in GST, it is referred that section 69 subsection 1 of CGST Act clearly says, where commissioner is having reason to believe a person has committed specified offence. Under section 132 subsection 1 subclause A to subclause D of CGST Act. So there are 4 specified offences under section 132 subsection 1, and that is punishable under Roman 1 and Roman 2 of section 132 subsection 1 or subsection 2 of CGST Act. Then commissioner may authorize any officer in writing for arrest of such person. So what are these specified offences for which arrest can be made? 4 specified offences under section 132 subsection 1, and it is starting with whoever has committed or who causes to commit and retaining benefit out of it. So there are 2 terms: whoever has committed, or who causes to commit and retaining benefit out of it. For 4 specified offences, clause A, supply of goods or services or both without issuance of invoice, that is called cash sale. Issuance of invoice without supply of goods or services or both, that is called fake invoice and fake credit, wrongly credit availed on such invoices, resulting into wrong availment of GST input tax credit, clause C. Availing or utilizing credit on the basis of such invoices, or taking refund, erroneous refund, clause C. And 4th, GST collected but fails to pay beyond a period of 3 months from the due date of payment of taxes. So these are the 4 specified offences referred under section 69 subsection 1, and commissioner is having reason to believe that any person, whether registered or not registered, has committed the specified offences under clause A to clause D under section 132 subsection 1. If amount of tax evaded, ITC wrongly availed or utilized, or erroneous refund is being taken for these 4 specified offences, then arrest can be made under section 69 subsection 1, and it is being referred if amount of such tax evaded, ITC wrongly availed or utilized, or erroneous refund is being taken is more than 2 crore, because it is being referred under section 132 subsection 1 Roman 1 and Roman 2, or 132 subsection 2. If amount is more than 2 crore, tax amount I am referring to. ITC wrongly availed or utilized, or erroneous refund is being taken, amount is more than 2 crore, arrest can be made. But under section 132, it is being clearly mentioned what is called non-bailable offence or cognizable offence, and what is bailable offence or non-cognizable offence. So these four specified offences which I referred: supply of goods or services without invoice, issuance of invoice without supply of goods or services, wrongly credit availed or utilized on such invoices or erroneous refund is being taken, GST collected but fails to pay beyond a period of 3 months from the due date of payment of tax if amount involved is more than 5 crore or more. That is called non-bailable offence or cognizable offence. And arrest can be made. Arrest can be made if amount is more than 2 crore. So all other offences specified, these four offences which I referred, are called bailable offences or non-cognizable offences. Now this guideline has prescribed when arrest is being made, how it should be made, what are the parameters, when arrest should be made, and even after arrest, what are the process and procedure need to be followed by the field officer who are arresting the accused person. As we all know that arrest impinge the personal liberty of an individual, and it should not be made in routine and mechanical manner. That is what being stated in the guidelines. There has to be proper reason to believe, creditable information, concrete information in the hands of commissioner who is having reason to believe that such person has committed specified offence. Clearly said, arrest should not be made in routine and mechanical manner. Reason said it is impinge personal liberty of an individual violative of Article 21 to the Constitution of India. And further it is being stated in the guidelines that just because legal ingredients of specified offences are being met, as we read the provision under section 69 subsection 1 read with section 132, does not mean that, ipso facto does not mean that arrest should be made. Commissioner must look into the matter, why he should go and pass an order in writing for the arrest, and what could be those situations that such accused person may temper the course of investigation. Such accused person may run away, or there is custodial integration is required, or such persons are engaged in benami and bogus transaction for certain GST registration which is non-existent, fake. These are the cases specified where commissioner feel it is very important for the investigation to identify tax evasion, tax evaded, and there is mens rea. Word used, there is mens rea, ill intention on the part of accused person. Then only arrest should be made. But arrest should be made only when commissioner is having creditable information, concrete information, and then it is importantly required custodial interrogation. Having said that, when arrest is being made, what are the process need to be followed? It is being clearly stated in the guidelines that such officer must follow the Honorable Supreme Court judgment of D.K. Basu, important judgment. arrest memo properly defined the offences committed by the accused person, and before arresting such person he must be intimated the reason why he is getting arrested. An arrest whenever made, it should be made as per Code of Criminal Procedure 1973, read with the GST provision 69 subsection 3, which I am referring to, for specified offences under section 132 subsection 1. So field officer must be well versed what are the provision existing under Code of Criminal Procedure for arresting the accused person. And such accused person must be presented before the judicial magistrate within 24 hours of his arrest. His health check must be done by notified medical officer. Then arrest should be made, and certain exception has been prescribed for women, female. It should be arrested by only female officer. So such process need to be followed. An arrest memo should clearly spell out the offences committed by him for the reason he got arrested, and this arrest memo, the copy must be given to the accused person, and there should be authorized person on behalf of accused person should be intimated, and that authorized person can meet with the accused person and represent before the authority. These are the pointers which is being stated and has been picked up from the Honorable Judgment of Mrs. D.K. Basu, Honorable Supreme Court Judgment. And here also it is being stated that even after arrest is being made, what are the process need to be followed in terms of investigation, custodial interrogation. His health check must be kept under watch, that he accused person is having good health. So these are the process need to be followed from Code of Criminal Procedure 1973 at par pari materia for GST provision when arrest is being made. So these are called non-bailable offence or cognizable offence. Whenever arrest is being made for bailable offence, it is being stated in the guidelines the deputy commissioner or assistant commissioner must grant bail on submission of bond or surety, and such accused person must comply with the condition prescribed for bail is granted by the DC, deputy commissioner or assistant commissioner. So as I clearly said, they have defined what are the specified offence for arrest and bail, and when it is non-bailable offence, an accused got arrested and he is being produced before judicial magistrate, he has to present his case before the judicial magistrate why he should be granted the bail. So accused person must demonstrate that he is being only alleged and he must be granted bail. Sometimes we have seen a situation that accused is also cooperating, providing the information, supporting and giving all the input to the concerned GST authority. Whether arrest can be made in casual routine manner. It is being stated in that guidelines, no. In such cases, ipso facto you should not arrest such person unless department feel that this guy, accused person, can tamper certain evidences, tamper the course of investigation. His custodial interrogation is required, or maybe this accused may run away. So there has to be existing region to be recorded in writing before commissioner authorizing the officer for arrest of such person. Well said. Now we have to really see whether these guidelines need to be followed properly or not, because it is being stated in the guideline that such guidelines are being issued in legacy pre-GST law for Central Excise Act and Chapter 5 of Finance Act for service tax provision. So field officer must exercise due diligence before arresting accused person, because arrest, as we all know, impinge the personal liberty violative of Article 21 to the Constitution of India. Principal DG, DGGI, Principal Chief Commissioner and Commissioner need to report arrest of accused person within 24 hours to member compliances. So such compliances procedure are now being inserted as per the guidelines. Once arrest is being made, then it's a responsibility of Principal DG of DGGI, Principal Chief Commissioner or Chief Commissioner to report to member compliance within 24 hours, and this record and data to be maintained and intimated. So this guidelines is giving a good platter in terms of what to be followed whenever we are looking arrest and when bail should be granted. There is one Supreme Court reference which is being given in the guidelines, that as per the Supreme Court judgment, and this particular thing I'm reading it out as such, which you can read in that instruction. It is being said, and they have referred the Supreme Court judgment dated August 16, 2021 in Criminal Appeal number 838 of 2021. And what is being observed by Honorable Supreme Court? Listen carefully. And it is as such, I'm reading it out, which is given in the instruction as well. We may note that personal liberty is an important aspect of our constitutional mandate. Personal liberty. Arrest should not be casual and mechanical. It is violative in terms of Article 21 of the Constitution of India. That's what the thrust and silver lining of Honorable Supreme Court observation in this particular case. The occasion to arrest an accused during investigation. So when investigation is going on and accused is being arrested, it arises when custodial investigation becomes necessary. So what is necessary need to be checked. Fact of the case. It should not be casual and routine manner, or it is a heinous crime, or where there is a possibility of influencing the witness or accused may abscond. In such cases, arrest can be made. Merely because an arrest can be made because it is lawful does not mandate that arrest must be made, and that is what it is being picked up in the guidelines stated. Even though legal ingredients are being satisfied for arresting a person, ipso facto does not mean that we should go for arrest unless necessity arises. So those are the things I have already discussed. I'm not repeating again, but this is the observation of Honorable Supreme Court, which is being quoted as a pretext for issuance of this guidelines under GST law for the arrest and bail provision. ये इंस्ट्रक्शन नंबर 2 dated 17th August 2022 एक गाइडलाइंस इशू की गई जीएसटी इन्वेस्टिगेशन विंग ने. उन्होंने कहा कि जीएसटी में अरेस्ट कब हो सकती है. जीएसटी में अरेस्ट कब होगी? जब कमिश्नर इज हैविंग रीजन टू बिलीव, कमिश्नर को ऐसा लगता है, रीजन टू बिलीव दैट एनी पर्सन हैज कमिटेड, एनी पर्सन कहा उनने, चाहे वो रजिस्टर्ड हो या अनरजिस्टर्ड हो, हैज कमिटेड स्पेसिफाइड ऑफेंस अंडर सेक्शन 132 subsection 1 and that is punishable under clause Roman 1 and Roman 2 of 132 subsection 1 or subsection 2 of 132 of CGST Act, then such commissioner may authorize the officer in writing to arrest such person. So ये offences क्या हैं? 4 offences आपको याद रखने पड़ेंगे. 132 subsection 1 कहता है whoever committed और causes to commit and retaining benefit out of it. 4 offences: supply of goods or services without invoice, cash sale; issuance of invoice without supply of goods or services, fake invoice; C, you're availing credit or utilizing credit on such invoices or taking erroneous refund; D, GST collected but fails to pay beyond a period of 3 months from the due date of payment of tax. अगर amount of tax evaded, ITC wrongly availed or utilized और erroneous refund taxpayer ने लिया है, amount is more than 5 crore or more, it is called non-bailable offences or cognizable offences. All other offences को इन्हें कहा bailable one, bailable offences और non-cognizable offences. अगर अरेस्ट होनी है तो इस गाइडलाइंस ने कहा अरेस्ट कब होगी, अरेस्ट करने के बाद डिपार्टमेंट को क्या क्या करना पड़ेगा. अगर नॉन बेलेबल ऑफेंस के लिए अरेस्ट हुई है और अरेस्ट अगर अमाउंट मोर देन 2 करोड़ से ज्यादा है तो अरेस्ट हो सकती है 69 सबसेक्शन 1 ऑफ CGST एक्ट. यानी जब अरेस्ट किया जाएगा तो अरेस्ट मेमो बनाना पड़ेगा डिपार्टमेंट को. उनको एक ऑनरेबल सुप्रीम कोर्ट का DK बासु का जजमेंट है, उसके सारे इंस्ट्रक्शन गाइडलाइंस फॉलो करने पड़ेंगे. अरेस्ट मेमो बनेगा, उसमें वो रीजन डालेंगे क्यों अरेस्ट किया जा रहा है, एक्यूज को बताएंगे कि आपको अरेस्ट हम क्यों कर रहे हैं. अरेस्ट करने के विद इन 24 आवर्स जुडिशियल मजिस्ट्रेट के सामने प्रेजेंट करना है फॉर रिमांड. तो ये सारे प्रोसेस उन्होंने इसके अंदर डाले. उन्हें यह भी कहा कि जब अरेस्ट कर लिया तो उसके बाद उसकी फिजिकल हेल्थ अरेस्ट करने से पहले भी आप चेक करेंगे और उसके बाद भी आप उसका ख्याल रखेंगे. जो ऑथोराइज पर्सन है अरेस्टेड पर्सन्स का, उसको आप इंटीमेट करेंगे एंड अरेस्टेड पर्सन को अपने ऑथोराइज पर्सन से मिलने का मौका होगा, अपनी बात रखने का मौका मिलेगा. और जहां भी हम बेलेबल ऑफेंस की बात करते हैं वहां डिप्टी कमिश्नर और असिस्टेंट कमिश्नर आपको बेल ग्रांट करेगा ऑन सबमिशन ऑफ बॉन्ड और सिक्योरिटी अमाउंट. एक्यूज को वो सारे कंडीशन कंप्लाई करने पड़ेंगे फॉर गेटिंग द बेल फॉर बेलेबल ऑफेंसेस. एंड जब इस तरह की अरेस्ट होगी तो रिस्पॉन्सिबिलिटी होगी प्रिंसिपल DG GGI की, प्रिंसिपल चीफ कमिश्नर की, चीफ कमिश्नर की, कि वो सारी चीजें विद इन 24 आवर्स अपने मेंबर जो कॉम्प्लायंस हैं उनको आप रिपोर्ट करेंगे. ये गाइडलाइंस इसलिए प्रिस्क्राइब की गई कि अरेस्ट impinge the personal liberty violative of article 21 to the constitution of India. रूटीन और कैजुअल मैनर में नहीं होनी चाहिए. It should be done judiciously. Just because आपके ingredients 132 subsection 1 rate with 69 subsection 1 meet out होते हैं तो आप किसी को अरेस्ट कर लेंगे. गाइडलाइंस कहते हैं ऐसा मत करो जब तक कि आपको ये लगे कि बहुत जरूरी है, नेसेसरी है. जरूरी कब है? आपको लगता है कि एक्यूज भाग जाएगा, आपको लगता है कि एक्यूज आपकी इन्वेस्टिगेशन को टेम्पर करने लगेगा, आपको लगता है कि एक्यूज पर्सन जो है वो बेनामी और फेक ट्रांजैक्शन में इन्वॉल्व है, नॉन एग्जिस्टेंट है. तो ऐसे केसेस उन्हें स्पेसिफाई किए जो एग्जाम्पल हैं, पर यही कहा कि अरेस्ट शुड बी डन ओनली एक्सेप्शनली. एंड बेल तो कहा जाता है ना, बेल इज द रूल, जेल इज एन एक्सेप्शन. सो हमें ये देखना है अरेस्ट तभी करना है जब वाकई बहुत जरूरी हो. और वही सुप्रीम कोर्ट का ऑब्जर्वेशन उन्हें गाइडलाइंस में पहला प्री टेक्स्ट बनाया, प्रिएम्बल बनाया और डाला. बट ये गाइडलाइंस सारे फील्ड ऑफिसर के लिए, उनसे कहा कि आपको कोड ऑफ क्रिमिनल प्रोसीजर के प्रोविजन भी मालूम होने चाहिए जब आप किसी को अरेस्ट करते हैं. तो ये सारी बातें इस इंस्ट्रक्शन में हैं जो डिस्क्रिप्शन बॉक्स में है, आप चाहें इसे डाउनलोड कर सकते हैं. एंड दीज आर द गाइडलाइंस. ऑफ कोर्स जो इशू की गई हैं लाउडेबल वन, एटलीस्ट कुछ क्लैरिटी उन फील्ड ऑफिसर के लिए कि आप कैजुअल मैनर में, रूटीन मैनर में अरेस्ट मत कीजिए. लेस बिजनेस सर्वाइव करना चाहिए। हाँ, जहां जो गलती की है, जिनने चोरी की है, दे मस्ट बी पैनलाइज्ड एंड आई एम वोकल अबाउट इट दैट जो गलती करता है उसे जरूर सजा मिलनी चाहिए, लेकिन जिसने गलती नहीं की है उसको परेशान मत कीजिए। ईज ऑफ बिजनेस, जीएसटी का मतलब गुड एंड सिंपल टैक्स। थैंक्स फॉर वॉचिंग, थैंक यू वेरी मच।